Debate. Reprise de débat. The Honourable Parliamentary Secretary to the Minister of Foreign Affairs.
Thank you, Mr. Speaker, and I'm glad to be able to be here today to speak to this bill. I think it's an important bill. I guess I'm a little disappointed today. I expected that we would be able to find unanimous support here and enthusiastic support for this bill. I hear the opposition, official opposition, complaining about language, and they want to toy with the language today. I'm concerned that they're perhaps not as concerned about the issues as they are about the wording in the title, and I think they need to refocus on that. And the Liberals today have been at least consistent, but a very strange position to take, where the member opposite seems to continually suggest that there's absolutely no cultural components anywhere that create specific practices. And I don't understand why we would take that, or why they would take that position. We all know we have universal challenges. He talks about spousal abuse and those kinds of things. That is a universal challenge, but we certainly are talking about some things that are very specific. So I'm glad to be able to speak today on Bill S7, Zero Tolerance for Barbaric Cultural Practices Act. And in the speech from the throne in October 2013, our Prime Minister promised that he would ensure that early and forced marriage and other harmful cultural practices, and this would include things like polygamous marriages, so-called honour-based violence, do not occur on Canadian soil. S7 amends the Immigration Refugee Protection Act, Civil Marriage Act, Criminal Code in a variety of ways, and it will address these practices. For instance, Bill S7 would create new and specific offences in the Criminal Code related to participation in a forced or early marriage ceremony. That includes things like removing a minor from Canada for the purpose of such a ceremony abroad, and establishes a targeted peace bond that can be used preventatively before the marriage and its associated harm occurs. But today I would like to build a little bit on what the Minister has just spoken about, and that is the proposed amendment to the Criminal Code that would limit the scope of the provocation defence. During the debates and committee proceedings in the Senate, there appear to be a number of misconceptions about the merits of the existing law, and there are good reasons for the proposed law reform. I hope that we can clarify some of those matters this afternoon. The defence of provocation is sometimes known as the heat of passion defence. This defence currently applies only to a charge of murder. It comes into play only if the murder has actually been proved, and if it's called a partial defence, which means that where it is successful, this defence claim does not give rise to a complete acquittal, but rather changes the verdict to manslaughter instead of murder. The defence of provocation is successful where the murder was committed in response to some sort of, it's called a wrongful act or insult from the victim that is so strong that it deprives, and again a quote, deprives an ordinary person of the power of self-control, and where the accused acted suddenly, again a quote, before there was time for his passion to cool. So, Mr. Speaker, although the defence, as I've said, is only partial, defence of provocation, it provides two very significant benefits to the accused if they're successful in applying for it. First, a conviction for manslaughter, as opposed to murder, leaves the judge with very wide sentencing discretion. A conviction for second-degree murder carries a mandatory sentence of life in prison and strict parole in ineligibility. However, a manslaughter conviction carries no mandatory minimum sentence unless a firearm was used, in which case it would be a minimum of 4 years. But in all other circumstances, manslaughter carries no minimum sentence. So at the sentencing stage following a successful provocation plea, the provoking conduct, the provocation of the victim, is taken into account again as a mitigating factor that can reduce the sentence. And as members can see, the sentencing benefit provided by the provocation defence is indeed very substantial. The second benefit of the defence, if it's successful, is that it allows a murderer to avoid the stigma associated with that label, the label of murderer. It is this aspect that we need as legislators to keep in mind when reviewing this provision. The law treats some killings as less blameworthy than others and effectively says that murder isn't always murder. Under the current law, which has been in the Criminal Code since 1892, to constitute provocation, the victim's conduct need only to be a wrongful act or insult. If the victim had a legal right to do what they did, this is not to be considered provocation, but that exclusion is very narrow. It applies to things that are legally and expressly authorized, such as police officers executing a search warrant. So provocation is presently considered where the victim's conduct was actually lawful. The defence is in fact frequently raised where the alleged provocation was conduct such as verbal insult or offensive gestures. The proposed amendment would limit provocation so it can only be raised where the alleged conduct, provocative conduct by the victim would amount to an offence punishable by 5 years in prison or more. So the defence would therefore be available in cases where a person kills in the heat of passion, provoked by criminal offences such as assault, things like verbal threats, criminal harassment, theft or fraud of property over $5,000, extortion, and there are a few others. Many provocation claims are in fact based on alleged provocation now of this type of criminal activity. The kinds of conduct that would no longer be treated as provocation under this Act would be things like verbal insults or other types of offensive but lawful behavior. However unpleasant or hurtful an insult may be, if it's lawful conduct, it should not excuse or mitigate murder or be allowed to do that. In the debates in the other place, some suggested this proposed reform goes too far and limits the defence too much. But it's reasonable to expect that Canadians can and should be expected to control their reaction to insult and offensive gestures with reactions other than killing the person. There are two primary objectives of the proposed reform. The first is to prevent the defence from being raised in future honour-killing cases, possibly successfully. We've seen examples of young girls and women who have been killed because they refused to follow their parents' wishes. This can be an issue, or this can involve an issue such as dating, or marriage partners, or how to dress. And these young people have the freedom in this country to make their own choices, and that actually is a fundamental freedom for everyone who is in Canada. And, Mr. Speaker, this is not just theoretical. This defence has been raised so far in at least 3 murder prosecutions where the murder could be characterized as honour-based. Thankfully, the defence failed in all 3 of those cases, which some, I guess, have used as proof that the law is working perfectly and doesn't need amending, but we would argue that this is an overly optimistic view. For one thing, all 3 cases were appealed on complex questions of law and evidence that included how the defence should or should not incorporate evidence of the accused culture. These issues are not definitively resolved by the courts. Despite some discussion of gender equality in a couple of the cases, none of the rulings established as a matter of law that the defence is excluded in honour-killing cases. It remains available to be argued by any person accused and convicted of murder. A teenage girl does not wish to marry the person chosen for her by her parents, and in refusing their wishes, they feel she insults their cultural heritage, community, and beliefs. If one or more parents were to react by killing the child, this defence could actually be used. It is appropriate, and we do not believe that it is appropriate that this could potentially be successful. A second objective of the proposed reform is to modernize the defence with respect to violence against women overall. It can no longer be used to excuse spousal murders resulting from the offender's violent reaction to the victim's lawful conduct. There is a long history of the provocation defence being raised and sometimes accepted to excuse spousal murder in Canada. Most disturbingly, this happens often in the context of marriage breakdown. These cases have not gone unnoticed. As one academic has noted in her review of the honour-killing provocation cases, she wrote, "While it may be true that gender equality is, at a rhetorical level, a fundamental Canadian value, and that violence against women is neither accepted nor encouraged in Canadian society, the operation of the defence of provocation in the criminal courts is certainly not exemplary of either of those values." Canadian judges and juries have accepted the defence where men murdered their current or former spouses or their former spouses' new partners in response to other forms of lawful conduct such as verbal insults, questioning paternity, refusal to talk privately following termination of a relationship, and real or perceived infidelity. These cases are very similar to honour-killing cases in that women are killed because husbands or other family members reacted violently when they failed to control their behaviour. Women and girls are still seen as property in some places and some minds of their husbands or their families. Their aspirations and desires are subjected to the will of others for their own good. While feelings of dishonour and shame are experienced at the family or community level in the case of honour killings, they are at the personal or private level in the case of spousal killings. So, Mr. Speaker, no one should be able to use the defence as or the excuse, the defence, that they violently harmed another person because they were provoked. Our bill addresses this issue in a way that removes that excuse, and I would urge all members to work with us and to support this important bill.